A very good day to Dr. Ani Mira and my fellow friends. Today I would like to talk about the case of Wong Foh Hin against PP. The facts of the case is about the appellant was convicted of the murder of his daughter. In 7 August 1963 in the evening, the appellant asked his daughter to massage him with eucalyptus oil. He sent 2 of his children to their mother and was on his own bed with the daughter under the mosquito net. After some time, the wife heard the daughter call out Dida. The wife opened the mosquito net and saw the appellant getting up and putting on his trousers. Appellant said he was going outside to defecate and asked the daughter to go with him. The wife said she would go, and when she passed through the door, Appellant stayed inside and shut the door, and she could not return. She reported to the police, who returned to the house. The daughter was not there, and the police took Appellant away. 2 days later, the daughter's bodies were found in a well near the house. The evidence was admitted at the trial in an accident which was the wife has complained to the village headman that the appellant has an incestuous relationship with daughter, and the village headman stating that if this occurred again, the matter would be reported to the police at 3 months ago. On the appeal stage, the question was whether the evidence of the above incident and also evidence of a similar incident just before the daughter's death were properly admitted. The counsel of the appellant contended for that the evidence of the incident which suggested an incestuous relationship between the daughter and appellant amounted to evidence of bad character should be inadmissible. While, if it was admissible, the trial judge should have exercised his discretion to exclude it on grounds that its prejudicial effects far outweigh its probative value. The court held that if the evidence was admissible, it cannot be inadmissible merely because it tended to show bad character or the commission of another offense. There was only circumstantial evidence of the murder. Strong and convincing evidence of motive would probably have high evidential value. So now we come to the reflections. So the general rule is Section 54, Subsection 1 of Evidence Act 1950 seems to provide some kinds of shield that protect the accused, whereby any evidence of his bad character is prevented from being tendered. Thus, any evidence adduced in court in a criminal proceeding must not show or tend to show that the accused has bad character. The reason why need to exclusion of evidence of bad character is irrelevant in showing the guilt of the accused, and its prejudicial effect often outweighs its probative value. Under the case of McCain and Attorney General of New Ways, in the first name is disallow admissibility of previous misconduct only to show likelihood of repeating, and the second name is allow admissibility of similar fact evidence if to show the current misconduct was designed to rebut the likelihood of its being accidental and to rebut any defense raised by the accused. However, these rules are not suitable in this judgment because it relies by the appellant. There are exceptions. Section 8 of the Evidence Act 1950 is dealing with 3 principal facts, which is motive, preparation, and conduct. In this case, because of the evidence shows that there is motive of the appellant to kill his daughter, hence the evidence shall be admissible. In the case of PP against Peter Kong, the judge explained that motive is that which induces a person to do a particular act. Every voluntary act has motive. Motive and intention must be distinguished. A person's intention in his decision to do or not to do a particular act, but his motive is the reason for forming that decision. In criminal cases, motive is really important when a case depends entirely on circumstantial evidence. However, when there is direct evidence to point the accused is guilty, there is no need to have motive to prove it anymore. It is not appropriate to introduce a document which will tend to implicate the bad character of the accused as well as to show that he was involved in another offense. To some extent, the law of evidence in relation to motive permits the court to allow evidence to show the alleged motive for a crime even though such evidence may suggest the commission of another crime by the accused. This is captured in the Section 8 of the Evidence Act 1950. Under Section 8, the following facts are relevant, namely, facts which show motive, facts that reveal preparations, facts which disavows previous or subsequent conduct of any person, provided if it is influenced by any facts in issue or relevant facts, statement accompanying and explaining acts, statement made in the presence and bearing of a person whose conduct is irrelevant, provided that statement if affects such conduct. Where a case depends entirely upon circumstantial evidence, the issue as to motive becomes important. The general principle of Section 54 is the evidence of bad characters supposed to be inadmissible. The annotation to that section at page 374 F of Warner shows that there are Indian authorities which establish that section does not make inadmissible evidence that is otherwise admissible. Part of that annotation reads, it should, however, be remembered that evidence which is otherwise relevant cannot become irrelevant merely because, besides being relevant on the point on which it is tendered, it incidentally shows that the accused to be of a bad character. If the evidence of motive incidentally discloses the bad character of the accused, the evidence does not, for that reason, become irrelevant. Moreover, in the case where it only can depend on circumstantial evidence, the strong and convincing evidence of motive will probably have a high evidential value, but it only limited in this case, which there is only circumstantial evidence of the murder itself. In a nutshell, I agree with the judgment that the similar fact evidence shall be admissible in this case because the case is depending on circumstantial evidence. The evidence might be the strongest possible evidence of motive, otherwise the justice cannot be served since it is only have circumstantial evidence. So when it comes to suggestion, Section 54 subsection 2 say that a person charged and called as a witness shall not be asked, and if asked shall not be required to answer any offence other than that with that he is then charged or is of bad character, unless the evidence shows that he is guilty of the offence. Second is he has personally or by advocates asked questions of the witnesses for the prosecutions with a view to establish his own good character, or he has given evidence against any other persons charged with the same offence. The precondition to utilize the Section 54 subsection 2 is the accused must be called as a witness. If the accused chooses not to give evidence, the Section 54 subsection 2 cannot be utilized. In my opinion, the basic principle of similar facts evidence act as an shield to the accused to avoid the prejudice to the accused. However, the court need to make a wise decision when they have such case they only have circumstantial evidence. There are three circumstances that Section 54, the shield of Section 54 may be broken, which is rescate, and Section 14 and Section 15 of the Evidence Act 1950. These sections are unique and become an important tool of evidence in assisting the Malaysian court of today to uphold the justice and fairness in their respective judicial decisions. Hence, the lawyer and the court should utilize this section to uphold the justice for the victim and for the benefit for the society. Thank you.